or the learned members from all the fraternity and especially the practicing IPs. This topic is quite relevant from the viewpoint of an insolvency professional who are either acting as an IRP or RP or as a liquidator. This is somewhere not a challenge for the practicing chartered accountants who are already into the field of audit and forensic audit. But yes, a person from a background of a law, person from a background with the company secretaries, it is always relevant that to have an eye on these transactions, all the related party transaction, what we have in Section 188 of the Companies Act, from the viewpoint of the accounting standards, from the viewpoint of what called arm length transactions. This is very relevant for irrespective of the background, but if a person is acting as an IRP or RP or a liquidator, it's quite important to oversee the transaction during the look back period. As far as the fraudulent transactions are concerned, which we are going to deal with Section 49 and 66, there is no look back period. So irrespective of the term or the time prior to initiation of CIRP, when the transaction was undertaken, you need to brought into the attention before the adjudicating authority for the best interest of the creditors of the corporate debtor. But as far as the preferential transaction is concerned, Anuj Jain judgment is very clear, and again thereafter a Puja Berry judgment, which has left no scope for a corporate debtor and its director to escape from saying that that was not a preferential transaction. So almost everything was covered as far as that two judgments are concerned. One is of Supreme Court, another one is from the Honorable NCLAT New Delhi. Section 43 is something we are going to discuss in detail. Apart from Section 43, there are certain more elements to be taken care of, such as undervalued transaction. Apart from preferential transaction, I'm talking about extortionate credit transaction. There are few judgments pertaining to this topic also. So as far as the undervalued and extortionate transactions are concerned, it is not always necessary to link up with Section 66. But yes, Section 66 give you a life wherein there is no look back period and there is no requirement that you need to identify the transactions with a related party and transactions with the non-related parties. I would like to first of all deal with the agendas, how we are going to deal with how is going to be the modus of today's session. So as far as the discussion is concerned, it is relevant, though it is known to everybody of us, the provisions of the law, but yes, I would like to touch upon that part initially. So I would like to touch upon the provisions of the code, first of all the relevant provision, whether it is Section 3, subsection 27, which has defined property, or whether it is Section 26, which is very clear that irrespective of the completion of CIRP, that will not impact my application made for avoidance transaction. We are going to deal upon 43, 44, 45, 46, 47, 48, 49 versus 66. And lastly, we are going to deal with Section 50, 51. An important part is the timeliness which is prescribed in Regulation 35A of Insolvency and Bankruptcy Board of India, insolvency resolution process for corporate person, wherein again, a timeliness is prescribed for framing an opinion to come to a judgment on this transaction, and lastly, to move an application before the adjudicating authority. We are also going to take care of Regulation 38, which mandates that whenever a resolution plan is proposed, you need to be very clear that how you are going to deal with the application if pending before the adjudicating authority for avoidance transaction. How, in case if the entries get reversed, how the amount is going to be utilized or to whom it is going to be distributed. Of course, it is for the sake of the benefit of the creditors and not the resolution applicant. So for the first half, I'm going to touch upon the subject, which is absolutely nothing beyond what is stated in the code. But the moment we will be out from it, we are going to touch upon the subject of the relevant judgments which are passed by the Honorable NCLT, NCLAT, and yes by Honorable High Court and Supreme Court. So that is going to be the two phases in which we are going to deal in detail with the topic. During the initial course of discussion, I will be appreciating your views on the interpretation of Section 43 most particularly. I'll be happy to hear from your side. Interaction will make the things more interactive. It is going to help the participants as well as speaker in a great sense. So during the course, when we will be going through the code itself, I'll be happy to see your viewpoint on the subject. But the moment we will be out, we will be taking care of the decided judgment, and probably we may be holding a contrary view to that judgment. More specifically, Pooja Berry judgment, wherein it is clearly stated that irrespective of the intention, whether it is an intentional or unintentional, whether it was out of your need or it was out of your urgency, but if such transaction is giving any benefit, any preference to the creditor, then Section 43 is going to be attracted. Section 43, you cannot avoid the consequences, which is there under Section 44, which clearly states that the power of the tribunal to make the transaction reverse. So anyways, this is the first aspect I would like to touch upon, and that is going to be the code, starting with the definition clause, moving with 26, Section 25, and more particularly Section 44 and onwards. And the moment we will be completing that, we will be taking care of the judicial pronouncement of all the forums, including Honorable High Court. I'm sharing the screen for the sake of convenience of all the participants so that we can remain on the same platform as far as the reading part is concerned, as far as the understanding of the interpretation is concerned. I'll just share the screen. If it is visible, I will appreciate if you can acknowledge. Otherwise, I can again put some multiple efforts to share it with you.
No, visible. Yes.
Thank you, sir. This is the code we are going to first touch upon, and I will certainly like to have the disturbance in between from your side pertaining to the subject matter. I will appreciate each and every views coming from your end. The first thing is the foremost transaction apart from the property is the money. And we know that when a company is not predicting or anticipating, or when the company is not even think of initiation of CIRP against it, there are day-to-day transactions which keep on rolling between a company and its related parties. Most of the transactions are with the related parties because the companies in India, whether it is a private limited company or a public company, and this is the provisions of the Companies Act even, which allow a private and public companies to accept money from its director, which is not treated as a deposit. I'm talking about Section 73 of the Companies Act 2013, which permits a company to accept unsecured loan or a secured loan in whatsoever fashion, but from its director, if it is accepted for both private and public, it is not falling within the purview of the deposit from public. And moreover, such transactions are not falling itself within the purview of deposit at all. For a private limited company, there is a more flexibility which is provided by the Companies Act, which states that private limited company can also accept such kind of financial assistance in terms of unsecured loan or secured loan from the director's relative, and that will also not covered under the provisions of deposits. For a public company, there is no such kind of flexibility, but for a private company, not only the directors, but directors' relatives, that shall not form a part of the deposit. So that is the routine course of transaction for any limited or for any private limited companies. There is one more provisions of the Companies Act which we are aware of, and that is Section 185, Under subsection 1 of 185, there is a provision which states that company cannot give loan to its director or director's relative or to a firm in which a director of the company is a partner. So there is a provision which clearly states that company cannot. But there is one more section, 185 subsection 2 of the Companies Act, which allow a company to give loan to other company in which a director of the company is interested, subject to the condition the borrower company is going to utilize that money for its principal business for objectives. Why I'm dealing with the Companies Act first of all, because the transactions are governed by the provisions of the Companies Act. Under the IBC, we are going to deal upon what are preferential, but what are the transactions? This is very relevant for us to understand. And that's why these are the very important provisions of the Companies Act, which should be there in the mind before we deal into this subject, before we undertake the responsibility of IRP or the RP or a liquidator of any corporate person. Now, as far as the transactions under this sections are concerned, but here, when we deal into the property, word property is defined in section 3, and that is subsection 27, which clearly states that it includes money. It includes money. So the transaction without any property gets involved, without any tangible property gets involved, even if it is not goods, even if it is not actionable claims, even if it is not land and property, but even if it is only a money transaction, that is going to be covered under the aspect, covered under the provision, covered under the applicability of section 43 and all the other relevant provisions which we are going to deal with. So as far as section 3 clause 27 of the code is concerned, property includes money, goods, actionable claims, land and every description of the property situated in India or outside India, and every description of the interest including present or future or vested or contingent interest arising out of or incidental to any property. A definition which has almost covered all the aspects which a company can think of. It's not only the property or it's not only the description of the property, irrespective of whether its location, whether it is situated in India or outside India, and every description of interest, including present and future or vested or contingent interest arising of or incidental to property. So meaning thereby, almost all the transaction will be covered up when we will be dealing with section 43. And the very important aspect of section 43 is to put a party, whether it is a related or unrelated party, in a better position than what that position would have been if that company goes into liquidation. So if there is a change in the position, अगर company section 53 के viewpoint से देखा जाए, if we see from the viewpoint of section 53, which deals with the waterfall mechanism, and there is a hierarchy which is provided, and not only that, there is a priority which is provided in the provision of section 53. Now, if you are making somebody's position preferential, if you are putting somebody in some better position in comparison to what otherwise would have that position in case of that company goes into liquidation, then it is going to be under the purview of 43. But yes, the transaction may be a monetary transaction, or that can be a transaction out of the transfer of any goods or transfer of any property or transfer of the land or any description of any property in India or outside India, but which is having an aim of safeguarding or protecting the interest of somebody over other. So that is what we are going to deal with when we will be touching upon section 43. But apart from that, the most relevant aspect which IRP has to perform, section 25. The same section which talks about when COC, after getting an opinion from, or when RP place it before COC to decide upon the eligibility criteria for invitation of EOI. So I'm talking about same section 25, which also deal with, I said I would like to deal upon same section 25, which casts certain duties on the RP. And apart from the duty which is there prescribed under subsection 2, which states that RP shall undertake following action, namely, it is taking immediate custody and control of all the asset of the corporate debtor, represent corporate debtor with third parties, raising interim finance subject to compliance of 28, appointment of legal or other professional, including accountant, maintaining the list of creditors, convening meeting of the creditors, preparation of the IA, inviting prospective resolution applicant by inviting for invitation for submission of the resolution plan, deciding the eligibility criteria. But out of these duties which are defined in section 25, one of the duty which also includes, which is there in section 25(2), clause G, that is to file an application for avoidance transaction in accordance with chapter 3, if any. This is very important that you should take care of this provision very minutely, that states that if any, meaning thereby there is no requirement to extend CIRP cost in absence of this transaction. I've seen in many of the companies, the IRPs and RP has made a habit of appointing a transactional auditor or the forensic auditor. It is like appointing a valuer irrespective of the fact the company is having a property or not. And this does not make any difference in the outcome, basically. So the opinion should be framed, first of all, an independent opinion should be framed. Rather than appointing transactional auditor first and then to frame an opinion, it is first of all cast a responsibility on the part of the IRP or RP, whosoever he is. Because when I say 75th day that you need to frame an opinion, by that time RP gets appointed. So the term of IRP is very much limited, and within that limited term, there is a specified duties to be performed. But thereupon, when you are preparing for the sake of preparation of the information memorandum, during that course, you need to frame an opinion, because by that time you are no longer a stranger to the company. And during that course, you need to frame an opinion about preferential or fraudulent or undervalued or extortionate transaction. The things which you have opined before the COC, you may have your you may have the auditor also, from which you can get the necessary clarity that whether the opinion framed by you can be determined, and if determined, the application can be preferred before the adjudicating authority. But there is a timeline which is prescribed in regulation 35A(1), 2, and 3. To frame an opinion, there is a timeliness which is prescribed, that is of 75 days from the insolvency commencement date. In order to determine the avoidance transaction, PUFE transaction, what we call, that is preferential, undervalued, extortionate, fraudulent, such transactions are required to be determined by 115th day. And you need to move an application earlier, which was 135 days, now reduced to 130th day from the insolvency commencement date. I've seen, but the tribunals are liberal in terms of interpretation of this deadline, but I've seen few of the order wherein the timeliness was not complied, and hence the application which was moved by the learned RP got rejected. But again, I would like to say this timeliness, though it requires you to move hurriedly, but that should not bury the purpose of this code. So it is clearly stated that the said timeliness are again directory and not mandatory. But here I would like to say this deadline which are prescribed under regulation 35A(1), 2, and 3 are, in order to frame an opinion, the timeliness is of 75 days from the insolvency commencement date. In order to determine the opinion framed, to put a determination on the opinion, The timeline is 115th day from insolvency commencement date. And yes, you need to file an application for avoidance of transaction in accordance with Chapter 3, if any, up to 130th day from insolvency commencement date. Section 26 is very relevant because in 2018, into 2019, the law was not that clear in terms of whether this application, if pending, would survive after completion of CIRP and upon approval of plan. But Section 26 is from the very beginning of the enactment of the code, and this is not brought in through any amendment. This is not brought in through any amendment. And Section 26 is having its root from the very beginning, which states that the filing of avoidance application under Section 25(2) clause J rather, by resolution professional shall not affect the proceedings of the CIRP. So that proceedings will run independently and the CIRP will run independently. And the law is very settled even after the completion of CIRP and even after the approval of the resolution plan. This application will have its own life. And yes, it is mandatory upon a resolution applicant to have a provision in its resolution plan to justify that how this application is going to be dealt with. So Section 26 is very clear in terms of that filing of avoidance application under clause J of Section 25 subsection 2 by RP shall not affect the proceedings of the CIRP. I would like to further move to section, or rather section I would like to now touch upon two regulations which are relevant to the subject matter is Regulation 35A and Regulation 38 subsection subregulation 2. We are going to deal into that aspect before we deal into section 43 and onwards. Now the screen is all disclosing the regulation, and this is the Insolvency and Bankruptcy Board of India Insolvency Resolution Process for Corporate Persons Regulation 16. And I was talking about Regulation 35A, wherein we have recently discussed the timeliness which is prescribed under the code. Section 35A, Regulation 35A. And Regulation 35A make it very clear that this is the responsibility upon the part of the RP who is moving such application. Regulation 35A. As far as Regulation 35A is concerned, on or before 75th day of insolvency commencement date, the RP shall form an opinion whether the corporate debtor has been subjected to any transaction covered under 43, 45, 50 and 66 on or before 75th day of insolvency commencement date. It's the RP who shall form an opinion. And I must say that in order to form an opinion, there is no purpose spending some cost which is going to add on the kitty of CIRP cost. You need to frame an opinion. It has to be your independent judgment. Of course, to have a determination of such transaction, you require an expert opinion. You require some transactional auditor. You require some forensic auditor. But this is 75th day from insolvency commencement date. To frame an opinion, I don't think so that being an RP, you are supposed to engage somebody even to frame even an opinion. Regulation 35A subregulation 2, which talks about that the resolution professional, if he is of the opinion that this corporate debtor is subject to any transactions covered under 43, 45, 50 or 66, he shall make determination on or before 115th day of insolvency commencement date. In order to determine, you can have this specialist, you can have this experts before you, and based out of their report, you can claim some, or you can ask for some clarification. Rather jumping to a conclusion, it is most important that you should place it before the management of the corporate debtor, the suspended management of the corporate debtor. You can seek a clarification, you can ask for a clarification. for all the transaction which you have determined as a falling under 43, 45, 50 or 66. Sub-regulation 3 of section regulation 35A. As far as regulation 35A sub-regulation 3 is concerned, it talks about when you are supposed to move an application, where RP makes a determination under sub-regulation 2. He shall apply to the adjudicating authority. Yes, the language is very clear. He shall apply to adjudicating authority for appropriate relief on or before 130th day of insolvency commencement date. When you see the language of this code is having its peculiar clarity and a peculiar element. A code is having, or code is mix of the given deadlines. For everything to be done, there is a prescribed timeliness, which is one of the spatial element of this code that, but at the end of the day, when the judgment call this timeliness as directory and not mandatory, the things gets liberalized, the interpretation gets a flexibility. So when RP makes a determination under sub-regulation 2 of regulation 35A, he shall apply to adjudicating authority for appropriate relief on or before 130th day of insolvency commencement date. Now question arises, can there be a joint application? There are conflicting judgment, but I must say, you need to be very clear with regards to the transactions and the prayer which you are making before the adjudicating authority under appropriate provisions of the code. There is no bar to this joint application, but you need to have your pleadings very clear that what are the transactions you are claiming as preferential under 43, what are the transactions you are claiming as an extortionate under section 50, what are the transactions you are claiming as fraudulent under 66 or 49. You need to be very clear, because for a fraudulent and under 49 and 66, there is no look back period which is prescribed. So when you are moving an application for appropriate relief on or before the 130th day, and if you are moving a joint application, make sure your pleading should be very specific pertaining to each of the given provisions. Your relief should be very much confined to what you have claimed as preferential, what you have claimed as extraordinary, what you have claimed as undervalued, what you have claimed as fraudulent. RP shall forward a copy of the application to prospective applicant to enable him to consider the same while submitting a plan within the time initially stipulated. So meaning thereby, this applications which the RP has moved before the adjudicating authority, the copy of such application is also required to be circulated, should be forwarded to the prospective resolution applicant, considering the requirement of regulation 38 sub-regulation 2, which we are going to delve upon. The creditor shall provide to the RP. Creditor shall provide to the RP, because when you are dealing into this application, it is very important that you may face some trouble from the suspended management. You may face some non-cooperation from suspended management, but much of the transaction you can reconcile from the creditors also, and hence it is provided under sub-regulation 4 that creditor shall provide to RP relevant extract from the audit of the corporate debtor conducted by a creditor, such as stock audit, transaction audit, forensic audit, etc. So meaning thereby, there is not only the cooperation which is needed or which is required from the management, but also you can get an idea about such nature of transaction, such details of such transaction from the end of the creditors also, especially the secured creditor who holds majority of the information pertaining to the stock audit or transaction audit or forensic audit. Moving on to regulation 38, which is bit of importance. As far as regulation 38 is concerned, regulation 38 it is the mandatory content of the plan. I'm not going to touch upon what else are mandatory content, but the important in this connection is that it is Clause D, sub-regulation 2, the plan shall provide the manner in which the proceeding in respect of avoidance transaction or fraudulent or wrongful trading will be pursued after the approval of the plan, and the manner in which the proceeds, if any, from the proceeding shall be distributed. This is very important. We know there are certain things which are mandatorily required by the adjudicating authority when plan is put forth before them for its finality. The term of the plan or the implementation schedule, which is one out of it, who is going to be in the management and control of the business of the corporate debtor post approval of this plan, adequate means for supervision of the plan for which we have a monitoring committee. But the most relevant one is which provides the manner in which the proceeding in respect of the avoidance transaction, which are pending before the adjudicating authority, shall be pursued or will be pursued after the approval of the plan, and manner in which the proceeds, if any, from such proceeding shall be distributed. So this is one of the important aspect which requires that, and that is the only reason we were studying Regulation 35. Regulation 35, that's why it is very clear, sub-regulation 4, which we have seen in a very recent discussion, that it is the RP, if RP has moved an application, then in that case, if the RP has moved an application, it is the duty on the part of the RP, that sub-regulation 3A, that RP shall forward a copy of the application to prospective resolution applicant, which enable the resolution applicant to consider the same while submitting a resolution plan, because it is required, and that is what we have seen in Regulation 38, sub-regulation 2, clause D, that while proposing a plan before the COC and later on when the plan will be placed before the adjudicating authority for its final node, in that case, the authority is going to touch upon this aspect from the counsel of the applicant, that how the resolution applicant will pursue the application, will dealt upon the application, how the resolution applicant will dealt upon the application, which is made under Chapter 3 or Chapter 4, Part 2, after the approval of the plan, and in which manner the proceeds from such proceeding shall be distributed. Of course, it is always going into the ultimate benefits of the creditors of the corporate debtor and not to the resolution applicant. I would like to have your views on this connection up till the discussion what we have. And right now we'll be dealing with section 43 and onwards. So we will be touching upon the aspect of the transactions. We will be dealing with section 43, 44, 45. We will be dealing into section 46, 47, 48, 50 and 51, and lastly on section 49 and 66. So there are certain transactions which we are going to deal upon. We'll see what is the power of the adjudicating authority, because tribunal in the capacity of the adjudicating authority to have sufficient power to undo such transaction, to reverse such transaction, so that the loss which is caused to the creditor of the corporate debtor can be made good out of the beneficiary. So we will be dealing into the aspect of the transactions, wherein we will be very specific in terms of all PUFE transaction, whether it is a preferential transaction under 43, or whether it is an extraordinate credit transaction under section 50, or whether it is an undervalued, or whether it is going to be a case of fraudulent transaction. Before that, in case if you have something to discuss, if you have something to place before, if you need to have your views on the subject, please feel free to have an interaction. So again, we are back to the code, because we need to take care of section 43 and other relevant transactions, which we call preferential or undervalued or extraordinate or fraudulent. Section 43. There must be multiple insolvency professionals who must be participating this session. They must have moved to various applications under the topic which we are going to touch upon.
Sir, excuse me.
Yes, sir,
One
please.
query, sir. Regulation 35A of CRP regulation says that RP has to determine, shall form an opinion whether the corporate debtor has been subject to any transactions covered under Section 43, 45, 50, or 66. But in most of the cases, we see that the corporate debtor is not providing the records. In that case, we cannot form an opinion unless they give the records. We will
Sir,
be getting only limited records from the MCA portal.
I will be happy to see you, sir, in case if you can open your webcam.
Yes, sir.
Yes,
Sir.
ma'am. Yes, ma'am. Yes, ma'am. Ma'am, I can understand your concern. When we act as an insolvency professional and acting as an IRP or RP, the only authority, the only person who stays away from the entire proceeding is the suspended board of directors. And the only person who is close to the company's books are the suspended board of directors. The only person with whom they or the only person who are the most privy to the transactions are the suspended management. But as far as the IBC is concerned, there is a provision which states that in case if you are not getting necessary cooperation, always you can move an application under Section 19. But even after Section 19 application, we have witnessed that no such kind of submissions which are desired are available from the suspended management. And as you say that we only rely upon the data which is available on MCA portal or the data which is available with the concerned professional who are the statutory auditor or the company secretaries or internal auditors. And they moreover are again the persons from the suspended management only. In that circumstances, when you don't have any data, you can always take the benefit of the adjudicating authority and its order. But in case if the orders are being passed, but the suspended managements are not revealing their identity, the powers are numerous, the powers are extended before the adjudicating authority, but the only requirement is the adjudicating authority should act upon such power. Because, see, first of all, I've seen many of the cases wherein there is no data even available with the Ministry of Corporate Affairs due to non-filing of the mandatory returns. If I've been appointed as an IRP or if I've been appointed as an RP, and suppose if I don't get any information, then ultimately what I believe is there is no purpose putting nose on the process of CIRP when there is no life to that CIRP. Ultimately, it ended up with a conflict only. I must say that in that circumstances, if there is a possibility that you are not going to get any information, I think the banker are the most closest form through which you can identify that transaction undertaken with the banker and the corporate debtor. Such transactions are the only thing through which you can see that how the payments have been routed, where the payments have been routed. But the problem is, wherever the payments have been routed, you don't have any access to the other personalities or the other entities or the other body corporates or the other person to whom the amounts have been transferred. So I must say that practically it is very difficult, even though we know that the power is numerous, but I've seen very least cases wherein the transactions have been made undo or the transactions have been reversed. And one of the lacuna is in the case of personal insolvency, especially in case of part 3 of the code, which deals with a person as an guarantor or the corporate person as a guarantor. There is no such kind of transactions which we are dealing in this insolvency resolution process for a corporate person, which is applicable in case of a personal insolvency. They don't have any fear to make such kind of transaction which are not going to be reversed because there is no provision unlike what we are going to deal upon, which is applicable in case of personal insolvency. Right now, the code is not applicable for an individual or partnership firm unless the individual and partnership firm have extended the guarantee. But for them, there is no provisions of the nature which we are going to deal upon section 43 or 50, or we are going to deal into section 49 or section 66. So in that case, I feel that the bank statements are the only manner through which we can able to recognize, we can able to identify. Statutory auditor should be the first person to whom you can approach. You cannot get much benefit by approaching a company secretary, because company secretary will only act upon the instructions once he or she is going to get from the auditor of the company. So most connected persons, or the most connected stakeholder, which can give you an opinion, which can give you a smell of such transactions, are the banking authorities, the bankers of the corporate debtor, or the statutory auditor of the company. Other than that, I don't feel any possibilities of generating the information. And in case, even after approaching them, if you feel that there is no hope of getting any information or extended information, there is no purpose wasting your time on such CIRP. Better to resign. Because tomorrow, if some transactions will be open up, you will be the first person to be dragged before the court of law.
So one side we will not be getting the record. In another cases, no, we will be getting the record, but who will bear the cost? That is the big issue. I mean, applicant who has initiated the CRP, no, they will not come forward to incur any expenses. Even the financial creditor also will not come forward unless they give a guarantee that they will get some anything from the company. So
This
in
is
this
the hidden
situation, we
objective
cannot.
of the code. This
Yeah.
is something, a hidden objective of the code, that irrespective of, you can say maximization, you can say rehabilitation, revival, but the foremost, the applicant has moved an application with a clear intent of getting his stuck money back. So when he know that there is no possibilities to extend further, I would advise such kind of applicant to withdraw their application. Because if this application will survive, ultimately RP will be chasing such applicant, and applicant will be running far away from the process, as if he himself has borrowed and has committed a default. So I must say that I can understand this practical difficulty, irrespective of whatever is stated, what is stated in this rule book, whatever has been stated inside the code. But this is the practical challenges which are being faced in case of the small corporate debtor who has committed a default and are not within the vicinity of the tribunal, which are not within the locality of the RP, which are not within the framework, or who are basically not even, you can say, you have failed to even identify, or even if they are beyond your access. And in such circumstances, the entire application is going to be futile, because if you have been appointed as an IRP or RP, and you are thinking for giving a newspaper publication, for inviting a plan for such company, you are not going to end up by getting any plan, because you know that when you are not getting any information, who will be happy to come up with a resolution plan? So ultimately, this is going to end up with a liquidation, but the challenge will be the same which you have stated: who is going to bear the cost of the process? And if nobody is going to bear the cost for the process, ultimately it should be left before the adjudicating authority to decide. That directly the adjudicating authority may take a call for liquidation or for dissolution, because there is no prospect to, or there is no hope to process or to comply with the process, which is just going to add on the cost, and for which you will not be getting any remuneration, nor you are going to get any reimbursement. So this is the practical difficulty, of which the only answer is leave it to the tribunal, place it a clear picture before the tribunal, that why this process should not be complied, and why the necessary order should be passed for either a dissolution, or else the refer the matter to any authority. Like, there are the possibilities wherein the registrar of companies possess ample of the power under section 206. The Ministry of Corporate Affairs possesses ample of the power under section 210. They can initiate some inquiries, they can call for information, and ultimately they have the ultimate power to pass an order for the dissolution of such entity. or to pass an order or to approach tribunal for winding up of such entity. So considering the interest of the stakeholder, the adjudicating authority should be the only authority to left upon, because you as an IRP or RP or liquidator are the officers of the court, and the court, let court take the final call on such companies, on such corporate debtor from which you don't have any hope to generate any information, or because in such case you don't have anything beyond dragging a company into liquidation. Sir, if you can please explain your question. Mr. N.K. Sharma, I have received one query from your side, and that is bit pertaining to some RERA transaction. But I must say that before we deal into this transaction, can we have section 43 before us? Because then we will be in a better position to have ample of discussion with regards to your subject matter. Mr. Sharma.
Yes, good morning, everyone. I think my transaction is relating to section 66, fraudulent transaction.
Correct. So can we reach out to that first?
Yes.
We will be in a better position to have an interaction on that.
The corporate debtor, they have received money and allotted one shop to A. They received full money and they have executed the sale deed also.
In favor of Mr. A.
In favor of Mr. A. Subsequently,
and that transaction was undertaken prior to commencement of CIRP.
Yes, prior to commencement of CIRP. Then later on, the promoter, it is a real estate matter. The promoter, he taken the money against that shop from B. Now the company, the corporate debtor has received double the money.
But in the first transaction which he had with Mr. A, what that sale deed was executed or not?
Yeah, sale deed was executed. He was the allottee after following all the business philosophy, whatever was followed by the corporate debtor.
So basically it was allotted to Mr. A, and on the same property, the corporate debtor has got some advance, got some amount.
Got some amount from B. And he was paying interest on that. So I understand that is a loan given by the B to corporate debtor.
Against the security as a property.
Yes, but no doubt the one document was executed, which is basically already decided by, in my number of cases, as a speculative investment only.
Correct.
So my question is they covered under section 66 as a fraudulent transaction? My first question is that.
Okay.
Second is is the RP required to file any avoidance application in this matter?
This is second question. And third one is?
But what are the duty of RP under these relating to these transactions?
So these are the three questions which are confined to this question.
Yes.
Should we directly reach out to section 4966, or should we follow the pattern which we are following?
See, the way you want, please clarify. My question is because this is
one case. I
have more than 50 such cases.
If you do at the time when you reach the section, it will be more.
I think we will be in a rightful position to have a thorough discussion on it. So let's have a look on section 43 first. And certainly I'm going to touch upon this question.
All right. Thank you very much.
Thank you, sir. So as far as section 43 is concerned, it's a preferential transaction and relevant time. So the God is great as far as placing relevant time for this transaction, and that's why the IRPs and the RPs can breathe during the process of CIRP. As far as the transaction of preferential nature is concerned, I've quoted two judgments which we are certainly going to touch upon. We are going to discuss in detail. One is Anuj Jain judgment, Jill and Jal, and the another one is the Pooja Berry judgment of Enclate. After going through both this judgment, I must say, the IRP and the RP will first of all observe the transaction which the corporate debtor had with its related party, and he will see that where the related parties are sitting, during the course of commencement of CIR? Are they sitting at comfort zone with their transactions squared up, or are they sitting on the same position, the position which it was prior to 2 years prior to the commencement of CIR? So he will be dealing into all the aspect with regards to the related party transaction. And apart from that, the transaction which the corporate debtor had with the unrelated party. And of course, such transactions are again for the betterment and for the intention of giving some benefit to the related party, who are either the surety or who are either the guarantor on behalf of the company. 43 subsection 1, where the liquidator or the RP, as the case may be, is of the opinion that corporate debtor has at relevant time, and yes, we are going to deal upon that aspect, which is right now very much within the minds of all the insolvency professional, relevant time. So it is 2 years and 1 year respectively for related parties and unrelated parties respectively. So where the liquidator or the RP, as the case may, is of the opinion that CD at a relevant time has given a preference in such transaction. Preference agar diya hai, if the preference is given, the word and is between, which states that if the preference is given, and this preference is given in such a manner as let down in subsection 2 of section 43, putting him in a better position in comparison to what position he would have been standing in case if company goes into liquidation. And in such manner as let down in subsection 2 to any person referred to in subsection 4, he shall apply to adjudicating authority for avoidance of preferential transaction and for one or more of the order referred in 44. So 44 is something, a power conferred upon the adjudicating authority if section 43 gets proven. So the corporate debtor at a relevant time, yes, we will be dealing into that aspect, relevant time, given a preference. And in order to see the preference, you need to check all the related party transaction, comparison with the other transaction which the corporate debtor had with its stakeholders, especially its secured, unsecured creditors, in such manner as let down in subsection 2. So very important, it's not only the preference, but this preference is putting them in heaven. Then in that case, the application can be made before the adjudicating authority to seek relief, which is under section 44. Now, this is a relevant provision of subsection 2 of 43, which states that a corporate debtor shall deem to have given a preference. Deemed to have given a preference. And I said this deeming provision will be attracted irrespective of the intent with which the CD has entered into such transaction. Whether CD has anticipated CIRP or not anticipated CIRP. But CD shall be deemed to have given a preference if there is a transfer of property or interest thereof of corporate debtor, and mark my words, regulation provision of section 3 subsection 27 that property includes money. There is a transfer of property or interest thereon of a corporate debtor for the benefit of a creditor. So either, and that is what you can see in majority of the cases, these creditors are basically the unsecured lender who are falling within the bracket of the promoter or the promoter groups, directors or their relative. So the transfer of property or interest thereof of a corporate debtor for benefit of a creditor. Or if it is a transaction with an outsider, of course, I will be entering into a transaction with an outsider, giving preference to A in comparison to B, or giving a priority to A over somebody, then intent is very clear. That is, ultimately, I want the liability of my surety and guarantor to be discharged. And very important, for an account of antecedent financial debt. So it is not the case wherein some property is transferred and you raised some money. Antecedent financial debt is a debt which was availed or the value was already generated. So the amount which was raised much prior to the transfer, antecedent financial debt or operational debt or other liability owed by a corporate debtor, and very important, and transfer has effect of putting such creditor or surety or a guarantor in a beneficial position than it would have been in event of the distribution of asset being made in accordance with 53. 53 is most dangerous for unsecured ones. And it is something which is totally not good for, or it is not meant for operational creditors. So if any transfer which was made, it can be a transfer of property or any interest thereof, which pertains to a corporate debtor, and that transaction was undertaken to give a benefit to the creditor, surety or a guarantor of the corporate, and generally the surety and guarantor, 99 out of 100 cases, they are basically the related parties. For an account of antecedent financial or operational or other liability owed by the corporate debtor, and of course, why to give a preference or how to give a preference is by the way of transferring, paying the money back, creating security, transferring the property, so that such creditor or guarantor or surety gets a better position, in a beneficial position, than it would have been in event of the company being liquidated and distribution of the assets been made under 53. Very relevant this is. Here you can argue on the grounds of routine course of business, ordinary course of business, intentional, unintentional, all will left apart if section 2 is getting, if section 2 of section 43 is going against you. Many a time such transactions are unintentionally done, but even unintentionally, but if such unintentional transaction giving a better position to such of the creditor, then in that circumstances, it is always presumed that such transaction were undertaken, and that's why it was against the interest of the other creditor, those who have been given a priority. But considering a selective prioritization, the other creditors have suffered during the course of liquidation. For the purpose of subsection 2, a preference shall not include following transfers. So this is the limited banner within which one may argue. The counsels who represent the corporate debtor in section 43 matter, they have the limited scope of argument and which is there in 43 subsection 3. The preference shall not include the following transfer. The transfer made in ordinary course of business or financial affairs of the corporate debtor or the transferee, but in Supreme Court in case of Anuj Jain judgment, Supreme Court has very specifically mentioned the ordinary course of business or financial affairs of the corporate debtor and the transferee. Mischief rule. They have interpreted or as and. The transfer made in ordinary course of business, that is what you need to see whether the transactions are in the ordinary course of business or not. And that's why in the beginning itself, I have mentioned 188, it is having its own importance of the Companies Act, related party transactions, arm length, ordinary course of business, or financial affairs of the corporate debtors and the transferee. So if the transaction was made in ordinary course of business or financial affair of the corporate debtor and the transferee, I must say, and the transfer is creating a security interest in the property acquired by a corporate debtor to extend that. So if I'm giving a priority to somebody and if I'm creating a new value, which we are going to study, new value, agar us transfer ki wajah se, if I'm generating some new value in that circumstances, you can very well met And in that circumstances, that will not be treated as if you have extended some favoritism or some preference. So transfer creating a security interest in a property acquired by the corporate debtor to the extent that such security interest to secure a new value and was given at the time of or after signing that security agreement that contain a description of the property as security interest and was used by the CD to acquire such property. पैसा दे रहा हूं कुछ चीज अवेल करने के लिए, प्रॉपर्टी ट्रांसफर कर रहा हूं कुछ बेनिफिट अवेल करने के लिए, and that is creating new value in the books of the corporate debtor, in the business of the corporate debtor, then it shall not be treated as if the preference is given intentionally. And I must say intentionally or unintentionally, if some preference is given for an antecedent debt to safeguard the interest of any creditor, to safeguard the interest of my own guarantors and the creditor and the sureties, whether my own or other, but just to secure their interest. And because of the transaction, if I'm putting them in a beneficial position, then it would have been in the event of the distribution of the asset under section 53 that will be treated in tantamounts to a preferential transaction. And I was dealing with the exception, and the exceptions are very limited, and you need to strongly argue your case on the grounds that transaction was in ordinary course of business, and it's not only an ordinary course of business for you, but also with the person with whom you entered into or entered upon those transactions. Or it is the ordinary course of business or financial affairs of both transferor and transferee. So it is the financial, if you are claiming that it is the routine course of business or it is out of the course of the financial affairs, then in that case you need to justify that how you will be claiming that this is the routine financial affairs. And yes, you can very well safeguard your case by showcasing that because of that transaction, the company has created a new value. So if the company has created a new value, then in that case, you need to showcase that how the transfer of property has generated a new value. So transferring security or transfer creating a security interest in a property acquired by the corporate debtor to the extent that such security interest secure a new value and was given at the time of or after signing the security agreement that contain a description of such property as security interest and was used by the CD to acquire such property. And such transfer was registered with IU. It is one of the important requirement. And such transfer was registered with IU on or before 30 days after the corporate debtor received possession of the property. Provided that any transfer made in pursuance of the order of the court shall not preclude such transfer to be deemed as. So by the order of the court, if I'm making such transaction, it will stay away. New value means the money or its worth in goods, services, or new credit or release by the transferee of the property previously transferred to such transferee in a transaction. So basically, it means that because of the transaction you have entered into with the other party, if you are generating some means which is adding on a value to the company, that is what the new value is. New value means money or its worth in goods, services, new credit facility if you are getting, or release by the transferee of the property previously transferred to such transferee in a transaction which is neither void or voidable by liquidator. So this will not be covered under the definition of, or this will not be covered under the purview of preferential transaction. And this is subsection 4 of 43, which states that if the transaction is made at a relevant time, which is 2 years preceding the insolvency commencement date, if the transaction was undertaken with the related party. But again, that will exclude if the amount is being transferred in the capacity of he being into the capacity of an employee. But you cannot pay an amount beyond what are generally accepted amount for an employee. So here you can showcase that if the amount was paid just because of a reason that the recipient was an employee, you may again avoid your case against you. So meaning thereby, if the transaction is with the related party, then such transaction was undertaken during period of 2 years preceding the insolvency commencement date. And if the preference is given to a person other than a related party, then such transaction was undertaken 1 year preceding the insolvency commencement date. So this is section 43. And here I would like to have your views on it, your views on both the judgments which are in the minds and the tongue of all the practicing insolvency professional, both Anuj Jain as well as Pooja Berry judgment. What you're saying in terms of section 43, because as far as section 43 is concerned, it is very difficult to establish if preference is given, then the only scope left with you from the viewpoint of the corporate debtor is either you can make out your case by touching upon that it was during the course of, or it was an ordinary business transaction, or it was undertaken in ordinary course of business, or it was the financial affairs in ordinary course of business, it was out of the financial affairs of both the corporate debtor and the one with whom the transactions was entered into. Because if you have a case of 43 subsection 3 clause B, that by transferring or creating a security interest, if you are creating a new value, then in that case, the only thing you need to check is whether that transfer was registered with the IU on or before 30 days after the corporate debtor received the possession of such property. But as far as the subsection 1 is concerned and 2 is concerned, I would like to say that what your stand in this case, because you will find when a company is going through a rough phase, when a company is going through a rough patch, or in a distress cases, we have seen many times that majority of the transactions are undertaken between a company and its directors, company and directors relative. It's not only the amount which is paid to them, but also an amount which is floated from them to the company. This is what the practically things are happening when company is facing the financial distress heat, when company is not getting any credit facilities from the banks or the financial institutions, or even from non-banking financial institution NBFCs. The only source and the only resource available with the company is the promoters or their relatives, promoters' friends. Though he is treated as an outsider, but what they generally do, they accept money in their own account, and then promoter and directors and the relatives are bringing those amount in the company. And yes, out of those pressure, out of those relationship, out of respect, out of the requirement, such amounts get transferred even back to them so that they get the same facilities again as and when required. And suddenly company goes into the liquidation. And suddenly company goes into CRP. And in that case, when such transactions get open, when you see from the viewpoint of section 43, you will find if the transactions are with the related party, you will find they all are covered under section 43. Because, and I must say that you need to have a checkpoint to see whether these are preferential or not. You need to see 2 years prior to the insolvency commencement date, where they were standing. 2 years prior to the insolvency commencement date, where they were standing. And as on the insolvency commencement date, where they were standing in comparison to other creditors of the similar category. And I must say, as far as the transactions with non-related parties are concerned, you need to check out of those transactions with unrelated party, which related party is getting benefited. And of course, the related party who is getting benefited was either a surety or was either a guarantor. So that is what section 43, 1 and 2 is all about. But subsection 3, which gives you a room to argue your cases, was out of the ordinary course of business. But you need to justify your stand by not only placing that it was your ordinary course of business, but it is equally the ordinary course of business for the other party also with whom the transaction was undertaken. Because we know that as far as the financial affairs are concerned, if it is only pertaining to the financial affairs of the corporate debtor and the other person with whom the transaction was undertaken is not having that financial affairs with the corporate debtor in day-to-day course of business, then in that case, you cannot take the shelter of 43(3)(a), I would like to have your views on it. You all must have filed section 43 applications in almost all of your matters. What was the relevance in that application? What was the transaction in that application? What you have prayed in that application? And what you have got in that application? सभी applications जो आपने IRP और RP की कैपेसिटी में की थी सेक्शन 43, क्या प्रेयर्स थे, क्या ट्रांजैक्शंस थे, क्या रिलीफ मिला और स्टेटस क्या है उन एप्लीकेशंस का?
We filed an application in 2019. Until date, nothing has moved. Only a reply has been filed by the respondent. Thereafter, nothing.
We have filed one application, but under section 66.
And what is the status of that application, ma'am? Is I'm audible?
In our case, we have filed
Yes, ma'am. And what exactly the status of that applications are? Anyways, so the only reason of touching into this question at this moment was section 44. How practically this is going to be, that is only a time can show, or only the time can tell. But yes, many times we have seen that transactions are getting reversed, at least in order. So this is what falls within the purview of section 44, and that is the power of the adjudicating authority upon movement of such application under section 44. Section 44, which talks about the adjudicating authority do have following powers. One is require any property transferred in connection with giving of the preference to be vested in the corporate debtor. वो undo करने का power tribunal के पास है in the capacity of the adjudicating authority under section 44 clause 1 subsection 1 clause A. If the property was transferred, it can be preferential, it can be undervalued also, or it can be in order to safeguard the interest of some surety, or it was with an intent to safeguard one of my creditor. So tribunal may by an order require any property transferred in connection with giving of the preference to be vested in the corporate debtor, but that will give a rise to a new channel of litigation, because now his interest is getting impacted, and he along with you will be fighting a case under 43 now. Require any property to be vested if it represent the application either of the proceeds of sale of property so transferred or money so transferred. Again, to undo transaction. Release or discharge whole or part of any security interest created by the corporate debtor. So suppose for any antecedent debt, if some charge is created over any property, to pass an order to release or discharge of any security interest. That is again falling within the purview of the power of the adjudicating authority. Require any person to pay such sum in respect of the benefit received by him. But the real question is why such person would be happy to pay the benefits back. Such sum to be liquidator to the liquidator or the RP as adjudicating authority may direct. And that is what I would like to say, that this is endless disputes. Direct any guarantor whose financial debt or operational debt owed to any person was released or discharged by giving preference to be under a new or revised financial debt or operational debt to that person as adjudicating authority may deem appropriate. What I would like to say in this case is, it is very good to see more of a success to get such an order, but it is very difficult to implement and execute such order. because it happens. When you see this, this is very relevant. I would like to say that order under this section shall not affect any interest in property which was acquired from a person other than the corporate debtor, or interest derived from such interest and was acquired in good faith and for a value. So one who has acquired such property in a good faith or in for a value, he will be at loss in this moment. And that's why it is now classified as an exception. But the moment we will be going further, it is very clearly stated in explanation para that even their interests are not safeguarded, because it is presumed that if the company is in CIRP, and when newspaper application is or newspaper publication is made, the newspaper publication is not only meant for inviting the claims, but it is also for the sake of an intimation to the stakeholder as a whole that this company is in CIRP. This is an exception which is provided that an order under this section shall not require a person who received a benefit from the preferential transaction in good faith or for value to pay a sum to the liquidator or the RP. But this explanation is something which is very important. For the purpose of this section, it is clarified that where a person who has acquired an interest in the property from another person other than a corporate debtor, or who has received a benefit from the preference, or such person to whom the corporate debtor has given a preference had sufficient information of the initiation of CIRP and is a related party. So there is no leniency with the related party. It's presumed that the interest was acquired or benefit was received otherwise than in good faith. And it is stated in explanation too that a person shall be deemed to have a sufficient information or opportunity to avail this information if a public announcement regarding CIRP has been made under section 30. This is section 43. Moving ahead with section 45, avoidance of undervalued transaction, that is PUFE transaction, and this is what we are dealing into. This is U. Section 45 states, liquidator or the resolution professional, as the case may be, on an examination, and I would like to say RP will be getting a good time to identify and to move such application, because when a stage comes for a liquidation, already the property is getting, or the value of the property is getting impacted day in, day out when the liquidation proceeds. There is again a dispute with regards to contribution of that liquidation expenses. Very difficult at this moment to identify and to move an application and to get the necessary consent from the SCC. But yes, for an RP, if the RP or the liquidator, as the case may be, on an examination of the transactions of the corporate debtor, determines that certain transactions were made during the relevant period under section 46, which is defined, relevant period the same, which were undervalued, then such RP or liquidator shall make an application to adjudicating authority to declare such transaction as void. To declare such transaction as void and reverse the effect of such transaction in accordance with this chapter. Again, very good to have this provision, but very difficult to implement and very difficult to get such kind of enforcement from the adjudicating authority for implementation of the order. So if the liquidator or the RP, as the case may be, on an examination of the transaction, determines that certain transactions were made during the relevant period under 46, which were undervalued transaction, and for this transaction you need to have your expert, you need to have the valuer with you to justify his case that why it was undervalued transaction. He shall make an application to the adjudicating authority to declare the transaction void, reverse the effect of such transaction in accordance with the chapter. Now, subsection 2 states, when a transaction will be considered as an undervalued transaction if a corporate debtor makes a gift to a person. There was no purpose giving a gift when your financial position itself is in stake. So transaction shall be considered as an undervalued where the corporate debtor makes a gift to a person. And when we say gift, it is rather an undervalued, it is unvalued transaction. Enters into a transaction with a person which involves a transfer of one or more asset of by the corporate debtor for a consideration the value of which is significantly less than the value of the consideration provided by the CD. And that's why you need to have the expert valuation before you. And such transaction has not taken place in ordinary course of business. Relevant period, it is the same what we have seen. If it is with any person 1 year prior to insolvency commencement date, if it is with a related party, 2 years prior to the insolvency commencement date. Adjudicating authority may require an independent expert. Very important. The adjudicating authority may require an independent expert to assess the evidence relating to the value of the transaction mentioned in this section. No purpose of having any expert if the transaction was made as a gift. But if the transaction with the person with whom, which involve the transfer of one or more asset by the corporate debtor for a consideration which is significantly less than the value of the consideration provided by the CD, then in that case, the adjudicating authority may consult an expert, may require an expert to assess the value of the transaction mentioned in the section. So at what value the transaction was undertaken and what was the value paid for that property by the CD. Very important. Here, not only the RP or the liquidator, but also the creditor can also move such application. Where an undervalued transaction has taken place, and the liquidator or the resolution professional, as the case may be, has not reported to the adjudicating authority. A creditor or member or a partner of the corporate debtor. Member or a partner of the corporate debtor, I don't think so that this will be a self-destructive many a times. But a creditor, as the case may be, may make an application. So here the application, the locus is given to the creditor also to make an application to adjudicating authority to declare the transaction void and reverse the effect in accordance with the chapter. So this is the relevant provision, section 47, which states that such application can be moved by the creditor of the corporate debtor. Adjudicating authority after examination of the application made under subsection 1. Here, the application is being moved by the creditors. If it is satisfied that the undervalued transaction has occurred and the liquidator or the RP, as the case may be, after having sufficient information or opportunity to avail information of such transaction, did not report to such transaction to the adjudicating authority, then in that case, this order will be passed against the RP or the liquidator, as the case may be. It shall pass an order restoring the position as it existed before such transaction and reversing the effect thereof in a manner as laid down in 45 and 48. Not only this, the adjudicating authority requiring the IBBI to initiate disciplinary proceedings against the liquidator and the RP, as the case may be. So this is very relevant as far as section 47 is concerned, that in case of undervalued transaction looking after the interest of the creditor, even a creditor can also move an application before the adjudicating authority. And if the adjudicating authority gets satisfied that the transaction was undervalued, and liquidator and the RP, as the case may be, having sufficient information or opportunity to avail the information of such transaction but did not report it such transaction to the adjudicating authority, which otherwise is required under 45, then the matter can be referred to the adjudicating to the IBBI for initiation of disciplinary proceeding against such IPs who was acting as an RP or the liquidator. What order it is which is going to be passed, the same as what we have seen 44, same as that in 48. The order of adjudicating authority under subsection 1 of 45 may provide following: requiring any property transferred as a part of the transaction to be vested in the corporate debtor. So जो property मैंने transfer किया है, the adjudicating authority will pass an order requiring such property to be transferred back, and such property shall form a part of the company again, the corporate debtor. Release or discharge any security interest granted by the corporate debtor. So suppose if any property is created, a security is created over such property, then adjudicating authority may, by passing an order, give a direction for release or for discharging either whole or in part of security interest which is created over the property by the corporate debtor, requiring any person to pay such some differential amount. So what the corporate debtor has paid is 100, and the corporate debtor has entered into undervalued transaction at rupees 20. So difference, requiring any person to pay such sum in respect of the benefit received by the person to the liquidator or the RP as the case may be, as the adjudicating authority may direct, and requiring payment of such consideration for transaction as may be determined by the independent expert. This is where we are. We done with the preferential, we done with undervalued, but yes, we are pending with extraordinary credit transaction first, and then I will be looking after the fraudulent transaction under 49, read with section 66. Yes, will appreciate your opinion, will appreciate your viewpoints, will appreciate your understanding to the subject, will appreciate your queries with regards to what we had a discussion about. So now extraordinary credit transaction. So company has accepted a loan from somebody at a rate of interest which are very much unacceptable and on a higher side in comparison to the other credit transactions which are generally taken place day in day out. Where the corporate debtor, now this is 50 and 51 we are going to take care of. 50 will be dealing into the aspect of extraordinary transaction, and 51 is the same what we have seen. We have seen 48, the power of the adjudicating authority. We have seen section 44. We have seen section 48. Similarly, in case of extraordinary credit transaction, we'll see the power of the adjudicating authority in this regard under 51, where the corporate debtor has been a party to any extraordinary credit transaction involving receipt of the financial or operational debt during the relevant period of 2 years preceding the insolvency commencement date. Here the relevant period is 2 years, irrespective of the person with whom such transaction was taking place. Where the corporate debtor has been a party to an extraordinary credit transaction involving receipt of financial or operational debt during period of 2 years preceding insolvency commencement date, the liquidator or the RP as the case may be may make an application for avoidance of transaction because the huge chunk of money is getting out, and that amount which is exorbitant, extraordinary transaction, may make an application for avoidance of transaction to the adjudicating authority if the terms of such transaction required exorbitant payment to be made by the corporate debtor. And this generally increase the stake of such creditor in the COC, and therefore the other creditor always have their say against such transaction. The board may specify the circumstances in which the transaction shall be covered under subsection 1. For the purpose of this section, it is clarified that any debt extended by any person providing financial services which is in compliance with any law for the time in force in relation to such debt shall in no event be considered as an extraordinary credit transaction. So financial service provider, if the debt is extended by the financial service provider in compliance with the law for the timing in force applicable to such transaction, shall not be treated as an extraordinary credit transaction. Power, the same what we have seen in 44, seen in 48, will find the same in 51, where the adjudicating authority, after examining the application made under subsection 1, is satisfied that the terms of credit transaction required exorbitant payment to be made by the corporate debtor, it shall by an order. मुझे जो क्रेडिट फैसिलिटीज मिल रही है या मिल सकती है या मिल सकती थी, by avoiding those facilities which I would have availed in the best interest of the corporate debtor, I availed or I entered into a transaction with a lender which is more stricter in terms of the payment of interest, exorbitant outflow of the company's money in the hands of such creditor. So where the adjudicating authority, after examining the application made under subsection 1 of 50, is satisfied that the terms of credit transaction required exorbitant payment to be made by the corporate debtor, it shall by an order restore the position as it existed prior to transaction, which is near to impossible, practically impossible. Restore the position as it existed prior to transaction. Set aside the whole or part of the debt created on account of extraordinary credit transaction. Modify the terms of transaction can be made possible. Require any person who is or was a party to the transaction to repay any amount received by such person. Next round of litigation will start. Require any security interest that was created as a part of extraordinary credit transaction to be relinquished in favor of the liquidator or the RP, as the case may be. So it sounds very good. You can make a very good relief clause, but after passing an order, to implement such order is the most difficult task. If I would have been in the place of lender and I'm getting an order from the tribunal mentioning the fact that my position will be restored, so my money is already flown away. Position, if restored, means I will be out from the balance sheet of the CD. Set aside the whole or part of the debt created on account of the extraordinary transaction. What about my money? Modify the terms of transaction. Very difficult for me to adjust to those modified terms. Require any person who is or was a party to transaction to repay the amount received by such person. So I have to pay the money back. The last thing which is possible for me. Requiring any security interest that was created as a part of the transaction to be relinquished in favor of the liquidator and RP, as the case may be. Section 51. Yes, I will be happy to hear you before dealing into section 49, and last one is 66. Any such application, if you have experienced, you must have made an application under undervalued transaction, which is what we have seen in 48, 47. Extraordinary credit transaction, if you have any experience with you to have a discussion with. So majority of the applications are being made under section 43, section 66, 49. For a non-running entity, there is no concerns for an RP or for an IRP or for a liquidator to touch base upon, to look back into such transactions. For an operative entity, yes, many of the things you can make out of section 43's due diligence. When you will be identifying the provision of section 43, you can make out many of the things, whether it is a case of 49, 66 or not. But when you say a transaction defrauding creditors, a transactions which is defrauding creditors. Now, I would like to say that question which was initially asked, we will be looking after that question at the end, because it do have some features, it do have some correlations, it do have some elements of section 43. So as far as section 49 is concerned, where a corporate debtor has entered into an undervalued transaction, as referred in subsection 2 of 45. An adjudicating authority is satisfied that such transaction was deliberately entered into by such person. Of course, when I'm transferring a property to X minus value, when I can generate a value of X, or when I myself have paid a value of X, then in that case, of course, that is for the sake of the benefit of my party, which ultimately results to loss to other creditor. So undervalued transactions, you can very well assess, and that will ultimately results to a loss on the part of one creditor. And that's why we have seen under section 47 that such an application can also be moved by the creditor. Such an application can also be moved against the creditor. 48. But as far as section 49 is concerned, wherein I am right now, the adjudicating authority would is satisfied that such transaction was deliberately entered into by the corporate debtor. And Mr. Sharma, I must say that yes, it was a deliberate transaction. When I as an IRP, I as an RP, I as a liquidator, or I as an auditor, or I as an adjudicating authority is placed before a case wherein a company over a property is entering into two different transactions. Here, the first interest which is going to be impacted is of the company is a separate legal entity. So I will be keeping the corporate debtor's interest first. I will not look after the buyer in a good faith. Neither I'm going to look after that investor, the speculative investor, who knowingly or unknowingly entered into a transaction with a corporate debtor. It's all the cases of lifting of corporate wheel. And that's why I will say that the first interest I'm going to look after is of the company first. Because you cannot expect anything from an artificial person at the end. So transaction in the name of company entered into with A and B both. A has paid a legitimate price of the property.
Yes.
If A would have paid illegitimate price, then probably the A would have been in the corner of the court.
Yes.
So if A is also a buyer of a property in a good faith, after assessing its viability, after assessing its locus, after assessing its titles, has paid an amount to a corporate debtor, the second party who is granting a loan over the property, which is no more a property of a CD, first of all, lack a proper due diligence, which otherwise could have avoided. Let us presume he made a due diligence, made nothing out of that due diligence, started making the payment of interest. The corporate debtor has accepted a loan over that property. Corporate debtor has started making an interest payment to that person. The money is floating out of the corporate debtor. I must say, extraordinary credit transaction, because entire transaction is going to be void tomorrow. Because the corporate debtor is knowingly entered into a transaction over a property.
Vinit, just for a minute. I hope the representative of IPA2 is attending this webinar, because they have organized this webinar. My request to the representative is, please note the deliberations just given by Mr. Vinit Nagar, because I'll be approaching you for clarification, formal clarification on this issue. Either IBBI should incorporate these things in the act or regulations, or they should not impose penalties on these accounts.
Sir, I don't know the background of the case, first of all. I don't know the background of the case, but I must say that...
My question is, I have more than 50 transactions like this. What do I do with these transactions? Some of them, majority has gone to NCLT, the person giving loan to the corporate debtor, that this is my shop, not the shop of the authority. And adjudicating authority has given maximum 100% decision that no, you have given funds, given loan to the corporate debtor, and original allotee is different. Someone else who is already allotee.
This cannot be done.
Yes.
This cannot be done.
What?
The favoritism or the favor to such party over the allottees.
Not a question of favoritism. Whosoever is allotee as per the record of the corporate debtor, he
is the ultimate owner of that property.
Yes. And the person who has given a loan to the corporate debtor against those particular shops, they have approached the NCLT.
It should be assumed that the corporate debtor and lender goes in hand by hand.
Yes, it is because they have received interest, and there is the document executed is article of agreement by which there is a buyback arrangement, and they have been given a security check of more than the double amount they have given to the company. Bench 1, they have already declared that these are the speculative investors.
Absolutely.
But IBBI is having a different view on this.
No, but my view, prima facie view, and that was the only reason to take up your question at the most relevant time when we are studying section 49.
Sir, my simple question is, is it a fraudulent transaction for the corporate data?
Question number 1, answer is yes.
How?
Absolutely yes. How this will be a fraudulent? I'm explaining that.
Yes.
Let us put myself in both the position. First, I'm putting myself in the position of allotee.
Yes.
I paid the price of that asset.
Yes.
If it is a commercial, to undertake commercial activities in
Maybe
future when I'm going to
any
that
property.
physical position.
Yes.
And for residential premises, I have taken a loan from XYZ bank. I'm paying interest. I'm paying rent.
See,
And I've paid a substantial price to the CD.
See, both are allottees as far as IBC is concerned, because they have imported this definition of allotee from RERA, and RERA is silent on that you cannot categorize between that. Allotee is allotee,
I'm not
whether it is a house.
categorizing. Once the allotment is done, there cannot be a subsequent allotment, is my point.
Yes.
Once the allotment is done to Mr. A is considered as an absolute owner of that property.
That's
and
right.
without the consent of A, no such transaction can be undertaken with any of the parties unless and until I am the party to that transaction.
Yes.
So who is the privy to this fact? There is only one person who is privy to this fact, is the company, who is touching upon the same property for the benefit of its own.
Yes.
Of course, a speculative investor having all the guts and power to enter into such transaction with no fear of uncertainty. Many of the things are also presumed and assumed to be known to that lender, who are very much routine with such transactions with the lender or with the builder.
Yes, definitely.
Right. When I'm tendering a money, when I'm extending a loan with a buyback clause, it is the utmost due care to be taken from my end. So it is an obligation, or it is an onus on my part to be very systematic as far as the title of the property is concerned. And once the registry is done, sell deed is extended, the information is in a public domain, and this is not something which is in shadow now.
That's right.
So in spite of being a professional lender, in spite of being a speculative investor doing investment of this nature for multifold times, if I'm making payment to the company, in spite of knowing that fact that the property on which I'm putting my stake is the property which is already sold out. A property, even though sold out or not, but a property which is surely going to be into the litigation. I'm honoring money to the company with all the facts in my hand that I may not get the money back.
Yes.
And the same fact is known to the company also. The company should be the first party in the litigation who is aware of both the transactions. Entering into this transaction, floating money in terms of interest in the name of speculative investor. Why the company should not be the first party of this fraudulent transaction? It should be the company first. Speculative investor on the other side.
Now, what is the duty of RP?
Duty is of the RP to see that the units which are sold out,
yes,
the residential plots, the residential building or the residential flats which are sold out, the registry is done, the sell deeds have been executed. Whether any encumbrances are there on such property apart from the encumbrances from the instance of the allotee, the first allotee. The moment I will get an idea that this property is encumbered with two different lenders, I should be the first person who is going to move before the corporate debtor and the lender by giving an intimation of the transaction to the first allottee in whose favor the transaction was already registered. From my perspective, responsibility is of the RP. This is fraudulent transaction. I'm not recollecting your third question, sir.
No, I just
Your
want to know
first question,
what are the duties of RP basically.
I answered that question.
So you are of the opinion that RP should file an avoidance application, but against whom? The shop is
Against
already
whom?
registered.
So answer is
See,
this will go against the corporate debtor as a party number one.
See, corporate debtor is not at loss at all. Corporate debtor they have received double the money.
No. Double the money, and that is what you intends to get it reversed. They have done, and that's why. To minus those doubled money, you are firing against them. So against whom you are going to go? And I say that the first person against whom you should move this application is the authorized signatory of those sell deed. The authorized signatory of those agreement which was entered between the corporate debtor and the speculative investors, whether those are the authorized signatory in the capacity of board or the partner of the LLP or even otherwise. And you should not leave the investor, the lender, who paid a price on that property, the property which belongs to somebody else. So you should also move an application against that speculative investor.
If the lender is aware of all such thing that this shop already allotted and belongs to someone else,
he will not get relief, and that is what we have seen in all the foregoing provisions. We have dealt with section 44. There is an explanation provided. There is an exception.
My question is relating to that. If the investor, second investor, if he's aware of the facts that this shop has already been allotted to someone else, and he is just extending a loan under these circumstances, do you feel it is a fraudulent transaction?
Absolutely a fraud by both the sides on each other. Absolutely a fraud. I am not going to lend to somebody who will pay me X.
What is the corresponding sections relating to such type of transactions?
Sir, we have dealt into section 44. We dealt into section 44. We dealt upon section 47, 48.
Forty-eight is undervalue transaction. These are not undervalue transaction.
No, sir. These are basically, I'm not talking about undervalued. I'm talking about the relief which you are going to pray for. If you see section 44, sir, please see section 44. Yes. Though it talks about a preferential. Please go through explanation 2. At page 53 of my screen.
This explanation 2. A person shall be deemed to have sufficient information or opportunity to avail such information if a public announcement regarding the CIRP has been made under section 13. This is the explanation 2.
Yes. So person shall deem to have sufficient information. Let's not go into it whether he was aware or not. My point is deemed awareness with regards to this information. Now, let's presume that if the transaction was undertaken, a person shall deem to have sufficient information or opportunity to avail such information if public announcement regarding. Now, here let us, if I say, I'm the lender, I'm the lender, leave CIRP aside, leave CIRP.
Yes.
If I'm the lender intending to lend, or I'm a speculative investor and I'm relying upon the property which a builder is proposing, which a builder is tendering, I should be the first person to have a due diligence or to do the background check of the property. And this background check of the property can be easily identified from the registry office.
Yes, definitely.
So in that circumstances, today, after the enactment of the RERA, things are very much stricter. in terms of compliance or in terms of disclosure. Now, in spite after knowing the fact that the property on which I'm putting my skin is not going to be mine, is already a property sold out, and on keeping that property into consideration, if I'm granting a loan with the hope that buyback clause is going to be in my favor, the second question which will come is, with what confidence I'm entering into a transaction. If I have got the necessary confidence from the promoter of the corporate debtor, then I will be equally responsible as what they would be if the transactions will be open up.
See, Vinit
I will
ji,
appreciate your views, sir, on it. I will appreciate your views on it.
what I'm going to tell is we need to seek from all this real estate matters. They are facing problem and litigation relating to these such kind of transactions only. This is not the one. Maybe there is a double sale also. Here it is the sale at allotment as well as the funding. There are a number of cases where it is a case of double sale also. The one particular shop is sold to number of
two different person.
If although IBC and regulations both are not clear anywhere that an avoidance application is required to be filed on this account. My simple request is either all this, the IBBI should take a cognizance, all stakeholders should take a cognizance of these facts. Either they should make a clear provision in the IBC and regulations that these are the avoidance, the RP is supposed to file avoidance application in such matters. I think the litigation will go 10 times.
Got your point, sir.
Either IBC should make, IBBI should make a clear provision in IBC relating to such kind of projections.
But I must say, if your intention is to see from the IBBI, to listen from the IBBI that RP should not be held responsible, then I must say this is very, this is something which is a high expectation from the board or the regulator, that why the IP should not be held responsible for the task which is falling all within the purview of his job.
See, from the RP's perspective, both the party has submitted the financial creditor who was extended loan. He has already submitted his claim, and his claim is accepted. And whosoever was having any grievance, they have gone to NCLT, and NCLT has rightly observed that you are a speculative investor. It was in your the particular shop has already been allotted to someone else, so that the allottee is the actual owner of that property. You have invested the funds, and your claim has already been accepted by the RP in relation to the funds you have provided to the corporate debtor. Matter ends.
So there will be one more extended, or there is one more addition to the creditor,
yes,
which was, and see, I must say that you cannot say that they should not. Here in this case, ultimately, the first party who is privy to this transaction, why that party should not be first dragged under section 49 or section 66? My first point. Acceptance of the claim is based on the books. Books are prepared by the management.
He is the allottee. He is the allottee, and the corporate debtor has discharged their obligation that sale deed is registered in his favor. Now, how he is concerned.
Sharma sir, I request for a specific query that can be addressed towards end.
Okay,
this was my specific query only.
So that can be. If
let's go into 49, because I think a preliminary view to this three transactions or three questions. The first was whether it is fraudulent. Answer was clearly stated yes. Whether RP will be held or whether it is an obligation on the part of the RP to move such application. Answer is yes. As far as duties are concerned, that is also explained. But in any case, we are supposed to discuss or deliberate upon it. We can very well take in, or it will be taken care of at the end. For the interest of all the participants, I'm moving into 49, 66, so that we can take rest of the time for all the practical judgments. So when the corporate debtor has entered into undervalued transaction as referred in 2 of 45, adjudicating authority is satisfied that transaction was deliberately entered into by such person. When I'm moving a transaction or when I'm entering into a transaction which is undervalued, Of course, we have seen in section 47, and that's why that gives a rise to a creditor to move such application, because any favoritism with one of the creditor in terms of undervalued transaction is impacting the hope of the other creditor. In that circumstances, adjudicating authority, if it is satisfied that transaction was deliberately entered into by such directed by the corporate debtor, for keeping asset of the corporate debtor beyond the reach of any person who is entitled to make a claim against the corporate debtor. So by entering into a multiple transaction, if the intention is for keeping the asset of the CD beyond the reach of any person who is entitled to make a claim against the corporate debtor, or in order to adversely affect the interest of such person in relation to a claim, then adjudicating authority may make an order restoring the position as it existed before such transaction, as if the transaction had not entered upon, and protecting the interest of the person who are victim of such transaction, provided that an order under this section shall not affect the interest in property which was acquired from a person. This is again a person buyer in a good faith. It shall not affect the interest in property which is acquired from a person other than the corporate debtor and the acquirer in a good faith for the value and without notice of the relevant circumstances, or affect any interest deriving from such interest, and shall not require a person who received a benefit from the transaction in good faith for a value and without notice of the relevant circumstances to pay any sum unless he was a party to a transaction. So basically, this extraordinary transaction or this is undervalued transaction is touching upon section 49, is having some smell at 49, which states that if the undervalued transaction was undertaken or entered into in order to keep the asset of the corporate debtor beyond the reach of the person who is entitled to make a claim against the corporate debtor over such property, and that transaction was undertaken in order to adversely affect the interest of such person in relation to a claim, then NCLT, qua adjudicating authority, may pass an order restoring the position which was existing prior to such transaction if the transaction has not even entered upon, and protecting the interest of the person who are victim of such transaction. This is 49. And finally, we need to have a final discussion on 66. And make sure we are going to take care of it, but yes, no civil code to have any jurisdiction. And that's why the ultimate authority will stay the NCLT only when these transactions are going to be litigated. As far as section 66 is concerned, that is a fraudulent trading or wrongful trading. Again, Sharma Sahab, this is again going to be very relevant for the sake of your query. If during the CIRP or liquidation process, it is found that any business of the corporate debtor, the business of the corporate debtor we are dealing with, builder selling property on one side, entering into an agreement with an investor on the one side, during the CIRP or during the course of liquidation, if it is found that the business of the CD has been carried out with an intent to defraud creditor, allottee is a creditor, and the first allottee is undisputedly a creditor in a good faith. During the CIRP or a liquidation process, I'm not reopening the question, but I'm just recollecting what was discussed. If during the CIRP or a liquidation process, if it is found that the business of the CD has been carried out, and that you can only able to found when you are getting claim from two different person over a same subject matter, which is property. During CIRP or during the course of liquidation, it is found that any business of the CD has been carried out on with an intent to defraud the creditor of the corporate debtor. Defrauding the creditor, I must say, knowingly entering into a transaction with a speculative investor, with the assumption that speculative investor has not made any due diligence, but knowingly touching upon the interest of that creditor, prejudicially defraud the creditor of the corporate debtor, or for any fraudulent purpose, the adjudicating authority may, on the application of the RP, application is required to be moved, may on an application of the RP pass an order that any person knowingly a party to carrying on the business in such manner shall be liable, and the parties who knowingly carrying out the business are always the promoter or the director. So company, so then board members, LLP, then the partners of the LLP shall be liable to make such contribution to the asset of the corporate debtor as it may deem fit. The things have been left open-ended. The NCLT, that is the adjudicating authority, may on an application of RP shall pass an order that any person who were knowingly a party to, not knowingly a party to the transaction, but knowingly party to the carrying on the business in such manner, shall be liable to make such contribution to the asset of the CD as it may deem fit. On an application made by RP during CIRP, the adjudicating authority may by an order direct that a director or a partner of the CD. So from the viewpoint of company and LLP, it is stated that a director or the partner of the CD, as the case may be, shall be liable to make such contribution. So from our example, we are keeping both the allottees and the investor aside, directing a director and the partner of the CD, and they shall be held liable to make such contribution to the asset of the CD as it may deem fit. Before the insolvency commencement date, such director or the partner ought to have known that there was no reasonable prospect of avoiding the commencement of CIRP in respect of the CD, and they have not exercised due diligence in minimizing the potential loss to the creditors. Notwithstanding anything contained in the section, no application shall be filed by an RP under subsection 2 in respect of such default against which initiation of CIRP is suspended as per 10A. So when it is a case of 10A, it is not falling within the purview of adjudicating authority. They are out from the stringence, they are out from the jurisdiction, they are out from the adjudicating authorities eye when the company is not in CIRP. So this is something which is very much natural to understand. For the purpose of this section, a director or the partner of the CD, as the case may be, shall be deemed to have exercised due diligence if such exercise was reasonably expected of a person carrying out the same function as are carried out by such director or partner anyways. But yes, these are the two things wherein one is based upon that transaction, other one is very much based upon the carrying out of the business operation with entire intent of defrauding the creditor. So that was confined to few transactions. It is confined to the business affairs of the corporate debtor, business operations of the corporate debtor. Here I would like to say that I would like to take a break of 10 minutes before we see the relevant judgments, the compilation of the practical judgments, what we have seen. We will touch base upon all this judgment, the relevant one, before we give a final conclusion to this topic. So we will be starting back at 1 o'clock and we will be extending 10 minutes beyond what the stipulated time is prescribed, subject to the consent of the participants and permission of the institute. Thank you. Shall we proceed, sir?
Yes, sir. Yes, Vinit ji. हाँ जी, हाँ जी.
The screen visible?
Yes, yes, visible.
There are few decided judgments which I would like to have with you. Law is settled in terms of Venus recruiters. So law is very much settled because in the case, I'm just going to, or I will go through the only relevant aspect considering the time frame left. But yes, in case of Venus Recruiters Private Limited versus Union of India, a question which was placed before Delhi High Court was whether NCLT has jurisdiction to adjudicate application filed under 43 of the code for avoidance of preferential transaction after the approval of the plan. Today, the things are very clear that yes, the power is with the tribunal. The power is with the adjudicating authority to adjudicate on such applications even after the approval of the plan. So, issue before the Delhi High Court, it was single bench judge, or it was first of all, this application was placed before the Honorable Delhi High Court, and the issue was whether the RP can continue to act beyond the approved resolution plan, whether the avoidance application filed under 43 can survive beyond conclusion of CIRP, and NCLT have jurisdiction to hear avoidance application after the approval of plan. Today we are of that view, and today we are strongly go before the NCLT and say that this is the pending application and this requires an adjudication. And furthermore, regulation 38 subsection subregulation 2 clause D is very clear that today the resolution applicant who is coming up with the resolution plan need to be very clear with regards to how it's going to pursue the plan, meaning thereby this application will be having its life beyond the approval of the plan. So on 26 July, NCLT Delhi has passed an order admitting Bhushan Steel Limited into CIRP under section 7 of the IBC, that application which was moved by the State Bank of India. Under the IBC, the Tata Steel Limited emerged as successful resolution applicant with the proposed resolution plan being approved by COC. 20th March 2018. Subsequently, March 18, the RP applied for approval of the plan by Tata Steel Limited before NCLT in terms of section 31 of the code. During the period of pendency of the approval of the application, RP discovered several suspicious transactions entered into by the CD with related parties, including preferential transaction by the CD with Venus Recruiters Private Limited. Consequently, before the final approval of the plan, RP had filed an application before the NCLT under section 25(2)J, 43 to 51 and 66 of the code. In the interim, 15 May 18, the resolution plan was approved by NCLT and which was upheld by the NCLAT also. The resolution plan was implemented in finality, and the new management, being Tata Steel BSL Limited, assumed the control of the CD. Meanwhile, under the avoidance application, NCLT proceeded to issue a notice to the respondent company Venus Recruiters Private Limited. So proceeding before the single judge of Delhi High Court, aggrieved by the notice in avoidance application, the Venus with whom the preferential transaction was undertaken, Venus moved a writ petition before the single judge of the Honorable Delhi High Court, contending that the proceeding born out of the avoidance transaction were rendered void and non-existent since CIRP is concluded and the management of the corporated has been taken over by Tata Steel BSL. Single judge of the Honorable Delhi High Court voided judgment in 2022, impugned judgment, because it was further referred before the double bench. Held that an application filed under 43 of the code for avoidance of the preferential transaction cannot survive beyond the conclusion of CIRP. An order concerning avoidance transaction must be passed before the approval of the plan. And this is not the case as on date. The single judge also held that the writ petition to be maintainable on the ground that NCLT does not have jurisdiction to delve into the issue apart from those related to the plan. This is again contested. Division bench has set aside the order. The impugned judgment was appealed by Tata Steel BSL, Union of India before Division Bench of Delhi High Court Division Bench. Observation of the Division Bench was, as far as the maintainability is concerned, it is observed that NCLT has power to adjudicate all the matter arising out of and in relation to insolvency resolution, arising out of and in relation to. The terms arising out of and in relation to were interpreted broadly by the division bench to include even avoidance transaction or application, notwithstanding that the plan has already been approved. Considering that NCLAT would have been the appropriate forum, absolutely. If the Venus was intending to challenge, then the application or the appeal would have been preferred before NCLAT. Considering that NCLAT would be the appropriate forum to entertain an appeal against the notice order, the division bench found that single judge erred in entertaining the writ petition, notwithstanding that the writ petition was found non-maintainable, but division bench proceeded to give its finding on the legal issue raised. Filing of avoidance application, the division bench noted that the timeliness mentioned in regulation 35A for filing avoidance application by RP are directory and not mandatory. That is what we have seen 35A1, that is to frame an opinion within 75 days. To determination will be based on my opinion 115th day, and 130th day the application can be made before the adjudicating authority, which was 135 day earlier. The bench further noticed that the practical difficulty that RP may face in collating information and forming an opinion for filing avoidance application within the specified timeline. There is no penalty clause under the code against the RP to failure to file avoidance application within the prescribed timeline. And further, there is no time limit given for adjudication on this application by NCLT. The duty cast on RP under the code to file avoidance application before conclusion of CIRP. Interpretation adopted by single judge and impugned judgment was thus set aside on the grounds that interpretation would lead to beneficiaries of support transaction of suspect transaction go scot-free, and thereby rendering the provision of the code otherwise. Continuation of the avoidance application by RP after the plan. So this is something which was later on brought in through regulation also. Division bench observed that the nature of avoidance proceeding is such that they are likely to last beyond the conclusion of CIRP, as they require investigation and discovery of suspect transaction. This is consistent with the provision of 25 and 26 of the code, regulation 38(2)D of CIRP. The observation made in the Insolvency Law Committee, the ILC report of May 22, the division bench clarified that the avoidance application and CIRP are two distinct and independent proceeding, and the office of RP does not become functious officio on conclusion of CIRP, and he may continue to pursue the application. Appropriation of amount from avoidance transaction, and that is what we have seen in regulation 38 sub-regulation 2D. So being a resolution applicant, you need to bring your resolution plan in a manner that dealt upon that how you are going to deal with the avoidance application pending before the adjudicating authority after CIRP. Regulation 38(2)D of CIRP regulation that have been introduced with effect from May 14, 2022 were noted by the bench. This regulation mandatorily require our resolution plan submitted after 14 May 22 to provide for manner in which avoidance application would be pursued after the approval of the plan, and the manner in which the amount recovered from avoidance transaction would be appropriated. Bench noted that the amount received from avoided transaction were not accounted for by TSL, of course not by a resolution applicant while submission of the resolution plan in view of the delayed filing. The bench held that TSL cannot be beneficiary of the amounts received, and the benefit are to be appropriated to the creditor. So it is not the resolution applicant but the creditor of the CD who will be benefited in case if the transaction get undone or reversed. It was held that the cases where the treatment of benefit acquired from avoidance transaction could not be accounted for in plan, such benefit would accrue to the creditors. The long-drawn dilemma regarding continuation of avoidance proceeding after the plan gets approved has been put to rest by the present judgment. So this is the history of this, why the CIRP applications getting concluded by but 43 or 66 gets on prolonging. The judgment clarifies the position of law that the proceeding for avoidance transaction under 43 to 66 of the code are independent of the CIRP and shall survive its conclusion. It further clarified that the resolution professional does not become functus officio with respect to adjudication of avoidance transaction and can continue to pursue the same post CIRP conclusion. This has commercial implications in CIRP regulation has provided that the plan should provide for treatment of avoidance proceeding and proceeds emanating therefrom post the approval of the plan. So this is the first one. Takeaway, we have already taken away out of it. This is Vijay Lulla case, and here also your views will be different because just now the things are very clear. After the approval of the plan by the adjudicating authority, the RP has no locus to maintain application, but that is what we have seen. But deliberately I covered because somewhere it is belonging to my own bench, NCLT Ahmedabad bench, before which we used to appear on regular basis. So this is the NCLT Ahmedabad bench, which has passed a judgment in 2021, holding that once the CIRP ends with approval of the plan, the RP has no locus to maintain an application under 4366. Further, it is observed that application under 66 after the approval of the plan can only be maintained by RA as per the mechanism adopted in the plan. But I must say, before that, just now we have concluded this, and it has made the things very clear that it can be very well dealt upon by the resolution professional. And this is what we have seen, that resolution professional does not become functus officio with respect to adjudication of avoidance transaction, and he may continue to pursue the same post completion of CIRP. This has commercial implications in CIRP regulation, have provided that a plan must provide for treatment of avoidance proceeding and proceeds, if any, emanating from post the approval of the plan, how that is going to be used. So I would like to say that the views will be reversed after going through that double bench judgment. Now this is pertaining to some undervalued transaction. Edelweiss Asset Reconstruction Company versus Net for India Limited. Undervalued transaction by the corporate debtor to keep asset beyond the reach of creditor to be declared as null and void. And that is what we have seen here. The power is also with the creditors. We have studied section 47. Enclet New Delhi bench in Edelweiss Asset Reconstruction Limited versus Net for India Limited passed a judgment on 29th April 21, declaring certain transaction of the CD as null and void, and directed the directors of the corporate debtor to compensate and pay for the loss suffered. Section 48. The corporate debtor has extended a master reseller agreement and trademark assignment agreement through which the majority of the asset of the CD was transferred to sister concern at a very mere consideration, which led to CD suffering losses, subsequently pushed CD into CIRP. In an application filed by RP under 66 of the code, Enclet held that the corporate debtor had entered into undervalued transaction with sole intent to keep the asset beyond the reach of its creditor, and that results to the applicability. The transaction will get null and void under section 66, 67 of the code. JP Infratech, this is so relevant and close to all the practicing professionals, especially advocates. JP Infratech interim professional, that is interim resolution professional, that is Mr. Anuj Jain versus Axis Bank Limited, preferential transaction. The Supreme Court in landmark case of JP Infratech Limited, interim professional, that is IRP versus Axis Bank Limited, also known as Anuj Jain case, enumerated some of the essential ingredient of preferential transaction. In this case, the corporate debtor, that is JP Infratech Limited, which was in CIRP, mortgaged 858 acres of land as collateral for the debt owned by holding company Jay Prakash Associates Limited, JIL and JAL. IRP of JIL filed an application to avoid this mortgage transaction, claiming that they were preferential, undervalued because there was no consideration coming in the JIL from JAL, and fraudulent under 43, 50, 45, 49, and 66, so that keeping its own property away from its creditors. NCLT ruled that it was not preferential. So NCLT ruled it is preferential. Appealed go before the Enclet. Enclet set aside the order, and finally the matter reached to the Supreme Court. Ingredient of preferential transaction, that is what we have seen. Insolvency proceeding in Allahabad bench of NCLT had been initiated by IDBI-led consortium under Section 7, seeking the initiation of CIRP against JIL. alleging that JIL had defaulted in repayment of its dues amounting to quite 26 crores after initially filing objection to IDBI's petition. JIL later on withdrew the petition and furnished consent for resolution plan. Moratorium was issued under 14, under which an IRP was appointed and the institution of suit and continuation of the pending proceeding, including execution of the proceeding, was prohibited. Several order was passed in ensuing bench of the petition to effect that the IRP was permitted to take over the management of the JIL and to ensure that necessary interest of the home buyer interest was protected. It is very relevant judgment from the purview of the home buyer also. It was during the pendency of the above proceedings that an application was filed on 6th Feb 2018 by IRP against a series of transactions surrounding the security interest created by JIL on 858 acres of unencumbered land in favor of the lender of JAL without any valuable consideration, and that is why it is also called as undervalued and fraudulent transaction. IRP had argued that the impugned transaction and the underlying transfer of the land amounting to asset stripping. The impugned transaction took place after the bank started classifying JIL as an NPA. So on the one side, the corporate debtors account is classified as an NPA. Other side, unencumbered land being transferred or given as a mortgage to holding companies lender, which are not your lender, due to its loan defaults. The IRP further contended that the land could have been sold or mortgaged by JIL to raise fund and to complete construction of flat had the impugned transaction not taken place. It is prudent to take note of that Supreme Court had in 2019 barred JAL from contesting for JIL assets. So this was the crux of the case. NCLT has allowed those applications. NCLT held that the impugned transaction had indeed been entertained to defraud the creditors of JIL in utter disregard of its fiduciary duty and duty of care. The NCLT further observed that the directors of the JIL as well as the related party JAL were fully aware of that JIL was in default, had been declared as an NPA by several creditors, and thus insolvency was imminent, and should therefore have exercised due diligence in minimizing the potential loss to its creditor. But instead doing that, JIL has entered into a transaction which ex facie gave benefit to JAL. NCLT decisively held that any transfer without consideration that is undervalued or counter guarantee could not be treated as having occurring in the ordinary course of business, since the impugned transaction did not in any way benefit JIL. They did not fall under the financial affairs. NCLT also made an important clarification that computation of the relevant time under 43(4)(a) of the code is 2-year preceding insolvency commencement date for related parties. For non-related party, 1 year. Here the transaction was undertaken with a related party, hence 2 years, and does not hinge on the date when the code come into effect. Based on all the above, NCLT termed the impugned transaction as preferential transaction under 43(2)(a) of the IBC. It is further held that the mortgage of immovable property without getting any consideration from your holding company squarely fall within the ambit of 45(1), which talks about undervalued transaction. I don't know why, but NCLT has reversed the judgment set aside in the order passed by NCLT by stating that the order passed by NCLT and was viewed that the impugned transaction were executed in ordinary course of business of JIL and held that none of the impugned transaction was undervalued or preferential and were not made with an intent to defraud creditor of JIL. But finally, the Supreme Court has made the things very clear. Supreme Court rendered its judgment in the matter of Feb 26, 2020 and quashed the NCLT order and approved the finding of the NCLT. Supreme Court dealt into two major questions: whether the impugned transaction were preferential transaction. Second, whether the lender of JAL could be termed as a financial creditor of JIL. Preferential transaction. The bench commenced with exploring certain facets of the code as well as treatment meted out to the preferential transaction under the corresponding codes. Supreme Court, while examining section 43 of the code, clarified that merely giving a preference, putting the beneficiary in a better position, was not enough. for a preference to become an offending one for purpose of 43, another essential element is that such event of giving preference ought to have happened during relevant period. So things made further clear that merely giving a preference and putting the beneficiary in better position is not enough. You need to check the look back period that ought to have happened during relevant time as specified in 4 of 43. That is 2 years with the related party. Furthermore, it has to be ensured that offending transaction does not fall with the exception, which deals with the transaction made in ordinary course of business or transfer creating security interest, secure a new value. An important observation made by the code was that in event of the above ingredient were satisfied, the transaction would be preferential irrespective of whether the transaction was in fact intended or even anticipated. So nothing with regards to your intentions or your mala fide or bona fide intention. If it is not falling within exception, it is very well falling under section 43. An important observation made by the code was that in the event the above ingredient were satisfied, the transaction would be preferred irrespective. The transaction would be treated preferential irrespective whether the transaction was in fact intended or not. Again, I would like to read furthermore, it has ensured that the offending transaction does not fall within the exception list, which deal with the transaction made in ordinary course of business or transfer creating a security interest with secure new value. Applying the above principle to the matter at hand, the Supreme Court stated that the impugned transaction clearly had the ultimate effect of working towards the benefit and advantage of JAL. Supreme Court laid emphasis on the fact that in the distribution waterfall envisaged under 53 of the code, JAL as an operational creditor of JIL stands much lower than in priority than the other creditor and stakeholder, which reinforced the beneficial position of JAL was placed due to impugned transaction. Ordinary course of business was also defined. Respondent had argued that the transferee in the impugned transaction were the lender of JAL, who ordinarily course of business was providing financial support with the loan and advances. Supreme Court has stated that NCLT's position that the matter was to be examined with reference to dealing and conduct of JIL and not for the JAL, because of course the loan was extended by the financial creditor of JAL to JAL, but it was not the JIL to whom the financial or the credit facility was extended, and the companies are separate entities. Supreme Court reiterated the NCLT's position that the matter was to be examined whether reference to the dealing and conduct of JIL for the purpose of 43. Furthermore, if the security interest created a secured value enhancement or result in strengthening the position of JIL, it was not treated as a preference. Relying on the purposive interpretation of the clause so as not to frustrate the intent behind the clause, Supreme Court held that 43A was to be read as follows. That is what we have read. The second relevant thing is Supreme Court held that the following question, I'm reading the relevant parts. Supreme Court held the following question must be considered to rule that transaction fall under 43. First, transfer for the benefit of creditor, surety and guarantor. So here the transfer was taken place for the benefit of the creditor of my holding company, which is impacting and prejudicially affecting the interest of my own creditors. Secondly, you are creating security over on your own property without getting any consideration from the holding, and you are in the verge of getting classified as an NPA. You are on the verge of getting admitted as in CIRP. So is the transfer for the benefit of creditor, surety or guarantor? The transfer related to antecedent financial debt, operational debt or other liability by the corporate debtor. Thus the transfer place the creditor, surety and guarantor in more beneficial position than it would be if the asset were distributed. If the transfer benefits a related party, was it made within 2 years? If the transfer benefits unrelated party, was it made within 1 year prior to CIRP commencement date? Is the transfer excluded under 43.3? So if it is not excluded, it is falling within the purview of preferential transaction. However, if it is the above conditions are met, the code ruled that preferential transactions are allowed if they occur during the ordinary course of business of both corporate debtor and transferee. And that is what I was talking about, mischief rule. When you see the law, It is the or which is stated, but Supreme Court has read it as it was occurred during the ordinary course of business of both CD and transferee, and resulting in the provisions of the new value to the corporate debtor. So if it is in ordinary course of business of not only the corporate debtor, but also the transferee to whom the preference is given, or in whose favor the asset is transferred, if it is falling within the ordinary course of business for both these entities, the corporate debtor and the transferee, and if it is resulting in, or if it is resulting in provision of new value, that I transferred the asset or I created a security over that asset and I'm getting new value, then only it will be exception. Otherwise, it will squarely fall under 43. Ordinary course of business, which is now not defined under the code, but Supreme Court has explained this in detail as far as this judgment is concerned. 43.3 states that transaction is not considered preferential if it was carried out in ordinary course of business or financial affairs of either of the corporate debtor or transferee. However, Supreme Court emphasized that this should be interpreted as corporate debtor and transferee, meaning both parties must engage in transaction with their ordinary course of business or financial affairs for it to be exempt from being treated preferential. The terms ordinary course of business and financial affairs are not defined in the code, but Supreme Court referred to the High Court of Australia's definition in Don's Distributing Company associated with Blue Star. So I'm not going into the case name, which described the ordinary course of business as transactions that are a part of regular flow of business, unremarkable and arising from no special circumstances. To determine if a transaction with a related party was in the ordinary course of business, the Supreme Court considered the specific relationship between the CD and related party. For example, it was noted that the CD mortgaging its asset to secure its parent company's borrowing, it is not ordinary course of business. And this is what was the case in Jill and Jal. Jill has created a security interest in favor of its holding company's creditor. So in that case, even the holding company has generated new value, how that can benefited Jill. So that was the case. And second one is Pooja Berry. So after going through this judgment of NCLAT, if you are representing the respondent side in section 43 application, you don't have much scope to argue, much room to argue. NCLAT and GVR Consulting Services Private Limited versus Pooja Berry, a very recent case, referred to the unilateral legislative guide for the purpose of understanding the meaning of ordinary course of business. It is referred to para 165 of this guide, according to which the term ordinary course of business is used to identify what constitute regular business activities. This allows businesses to make routine payments and enter into a standard contract without the risk of this transaction being voided in insolvency. Examples are rent payments or utility payments like payment to electricity, telephone, and payment for trade suppliers. The tribunal upheld the mischief rule applied by the Anuj Jain case when the court ruled that word or should be read as and, meaning that a preferential transaction must be a part of ordinary course of business for both the corporate debtor and the transferee to whom the property is transferred. And property we have seen in section 3 clause 27. Upholding the Anuj Jain case, the tribunal concluded that the corporate debtor which was involved in manufacturing an electronic project did not engage in ordinary course of business by taking financial assistance from related and unrelated party. The tribunal stated that term ordinary course of business and financial affairs should be interpreted narrowly and not include all financial transactions. They specifically noted that the money obtained from related and other party by the CD does not qualify as a part of the ordinary course of business or financial affairs of the corporate debtor, and intention is not relevant. NCLAT observed that there is no need to prove any fraudulent intent for a preferential transaction, and held that even if the transaction was fact intended or even anticipated, if the provision of 43 come into play, so transaction so entered would be regarded as a preferential transaction. So irrespective of the irrespective of the intention, if it is not fulfilling what is stated in 43.3, then you will be you will be trapped under section 43 and the transaction would be regarded as a preferential. The intent of the CD is not relevant. Since 43 envisages a statutory fiction, as has been noted above, whether the act is voluntary or not has no relevance while coming to the conclusion whether a transaction is preferential or not. So this is the one which was relevant as far as tribunal cannot suo motu classify a transaction as preferential. This is also a decided thing that tribunal cannot suo motu enter into this debate that a transaction is a preferential or not. It is always upon an application under 43 by the RP or liquidator under section 45 or under section 45 by a creditor or again by RP or the liquidator in case of undervalued transaction. Under 49 again by this RP or a liquidator. 66 by again RP and liquidator. So in Sahara India versus Shir Nand Kishore, NCLAT dealt with the question of whether the adjudicating authority can classify any transaction as preferential on its own without RP applying the same. And NCLT noted that converting an operational debt into financial debt through a loan agreement by RP was aimed at placing Sahara India in more favorable position. NCLT on its own accord classified this transaction as a preferential and which was challenged before the NCLT. So it was the NCLT which has noted that converting operational debt into financial debt through a loan agreement was aimed at placing Sahara India into most favorable term. But NCLAT has ruled that 43, it is responsibility of RP or liquidator to determine if the corporate debtor has given preference in transaction. They must then file an avoidance application to adjudicating authority for transaction to be avoided. In this specific case, the RP did not form an opinion that the CD had given a preference, nor did he file any application. Therefore, it is beyond the NCLT's jurisdiction to classify the transaction as preferential on its own. The appellate tribunal held that NCLT overstepped its authority by classifying a transaction as preferential without an application from the RP, as it does not possess the power under 44 to do so suo motu. This is the one. Undervalue transaction, we have multiple judgments with us. IDBI Bank versus JP Infratech, same thing. What we have seen, the JIL has mortgaged its own asset in favor of JAL's creditor without getting any consideration in return and hence classified as an undervalue transaction under 45. NCLT Mumbai in case of Ambit Finvest ruled that financial creditor cannot file an avoidance application for PUFE except undervalued transaction. This is something we are aware that creditor can only move an application if it is a case of undervalued transaction. That is what we seen in 47. This is because of undervalued transaction, an application can be filed by creditor, member or partner of the CD. NCLT Kolkata in PLY Com versus Nippon Alloy ruled that mere defense that asset had high depreciation value and that the same could not be sold at a better price is not sufficient ground. And you are aware in this circumstances, adjudicating authority may take the assistance of an expert to derive the price to determine the undervalued transaction. Mere ledger and the voucher would not be sufficient to prove or establish this contention. So there are multiple things to be taken care of, but yes, this is relevant. And this is what I was again and again reflecting upon 66 and 43. There is no look back period. NCLAT in case of Thomas George versus Ishwara Pillai and others ruled that there is no look back period for fraudulent transaction. And 3 years limitation period under the Limitation Act would not apply. Hence, the resolution professional can look back at any time preceding the insolvency commencement date for the purpose of determining the fraudulent transaction. Can a gift of property be treated as undervalued transaction? Yes. That is what we have seen. Gift of a property be treated as an undervalued transaction. That is what we have studied in 45. This is good one. This is good one. The CD was engaged in bullion trading and faced insolvency proceeding due to defaulting on a payment of 4.9 crore to Raksha Bullion. The appellant owned 41.3 crore to the CD. Appellant owned 41.3 crore to CD. which was written off by the debtors director before CIRP started. So the appellant in this case was owning 141.3 crore to the CD, and the CD's director have written off from its balance sheet. Can write off advance by CD fall. That is what we are into. Mr. Chetan, we are into that part only. The resolution professional alleges that this write-off as a fraudulent transaction under 66 of the code, seeking contribution to the debtor's asset from the appellant and directors. NCLT found the transaction to be fraudulent and ordered contributions from appellant and directors. It was appealed to the NCLAT. NCLAT observed that the fraud for the purpose of 66 of the code would consist of debt that the debtor has no intention or ability to repay, or it could also happen upon false representation of repayment intent. Additionally, usage of the phrase any person would include all the knowing parties who took part in the fraudulent transaction. तो अगर मुझे पैसा किसी से लेना बाकी है, and if that party is right now on the debtor side of the balance sheet, and if I'm writing it off, there was a possibility कि अगर पैसा आता, then this would have been paid to my creditor. But I'm writing it off by keeping that money out from the reach of my creditor is a fraudulent. Tribunal noted that unusual nature of loan given by the corporate debtor. A company cannot in lending business and lack explanation or security to write off. The tribunal noted the unusual nature of the loan given by a corporate debtor. A company not in lending business and lack of explanation or security for write-off. The tribunal held that transaction like this, which lack any security interest. आपने पैसा दिया है. You have lended money to an outsider without getting any asset in security, which lack any security interest or bank guarantee as collateral for the corporate debtor, and are subsequently written off from my books, can only be considered a fraudulent act intended to deceive the creditor or giving undue benefit to that debtor. The appellant was the main beneficiary of the scheme. The tribunal referred to the Ram Preeti Yadav case, reinforcing the principle that beneficiary of fraudulent transaction are presumed to be involved in the fraud. I'd like to stop share now, and we'll reach out to you for your concerns. We'll reach out to you for your questions. Would be happy to have your views on it, on the subject. Please, sir.
Yeah, Vinit, just a small query.
Please, sir.
One of the case of a liquidation, there is a fraudulent transaction. We have filed the application with the AA for under section 66. And whether the liquidation can be concluded and the petition will continue with the NCLT?
But dissolution cannot be concluded then.
So it will be kept on hold, because
absolutely. The reason is the default, the dispute pertains to, that is what my understanding is, the dispute is pertaining to the CD. You cannot pass an order of dissolution if any such kind of litigation is hanging.
In that particular case, because the CD is not traceable and the litigation may take...
you cannot differentiate a CD and its promoter. If the promoters are non-traceable, CD is right now facing this litigation before the tribunal. And in that case, if you are moving an application for dissolution, because when you move an application for dissolution, you need to mention that pending litigations, the detail about the pending litigation.
Yeah, I
the
think
tribunal will...
there is some provision that pending litigation I can transfer to IBBI so that can be continued.
Need to refer it once, sir.
Sorry?
In my viewpoint, I must say that as far as the regulations or the code is concerned, pending litigation always have some contingency in terms of liability. There is always a question that who will bear the liability or who will get the benefit out of those transactions. And I have not seen so frequent that tribunal are passing an order for dissolution in such circumstances or similarly placed circumstances. But we'll be referring in case if you can please cite upon those regulations. We'll have a look into it.
Okay.
Here is a question from one side: property transferred to divorced wife in alimony in the relevant period covered under the PUFE transaction. Is it keep the asset beyond the reach of the creditor? The company's property being transferred to wife in alimony. This is something which is not so acceptable transaction. The property of the company is the property of the company, and I cannot utilize that property for the benefit of the order or for my divorced wife. And if it is the case, absolutely it is a transaction. Director's wife, even in that case, the director's wife and the company's creditors are two different things. Giving a preference to a divorced wife, even though a divorce, but reaching or keeping a company's property out of the company's creditors' reach. This is 100% a preferential transaction.
And for the same thing for a Section 66 application, if the promoters are not traceable, can we seek the involvement of any government agency like EOW or ED or anything for
But
investigation?
to establish this fact of their dominance or establish this fact of their jurisdiction for a nature of CIRP wherein you are not getting any relevant person before you, you can always take that benefit because that is the power well within the purview of the adjudicating authority. But the point is, in absence of these people which are not even traceable, whether the information is traceable or not.
No, because the adjudicating authority has issued the warrants against the promoters, and against that warrants the CD is not appeared before the NCLT.
Yes, you can take the help of the agencies.
So we can ask for the
Absolutely,
adjudicating
yes.
authority for necessary direction.
Absolutely, yes, sir.
Vinit,
Thank you.
Vinit, may I ask you one question?
Please, sir.
Vinit, there is a transaction between the CD and its subsidiary. The subsidiary relies some amount from the assets which were transferred by CD to the subsidiary, and the consideration in respect of the assets transferred were not passed on to the CD. Instead, the CD was allotted with the shares of the subsidiary company. Is it a case of fraudulent transaction?
First of all, if I go by the valuation aspect, suppose if I'm getting the shares in consideration of the transfer of asset.
No, it's not so. They allotted the shares.
Got your point, sir. Got your point. This is nothing but this is what I'm getting in consideration. Shares are being transferred in my name. Was it valued or not? That is another thing. Was it of the same amount? Because when the shares are allotted for a consideration other than cash, the company who has allotted the share is always fall under an obligation to get the share valued. So point number one, whether it will be treated as a fraudulent or not, I don't think so. This will be treated or coming within the purview of that fraudulent.
The assets were financed by the bank, and those
Correct.
assets were realized by the subsidiary. The consideration thereof has not been passed on to the subsidiary CD. In turn, the CD could have paid the amount to the creditor, basically.
Absolutely. So coming to your second part of the question, that the finance was taken by the company over such land and which was not repaid, then this is considered as a transaction under section 49, not exactly 66, because you are not making payment to the creditor to whom it belongs actually. Absolutely, yes.
Thank you.
What type of transaction can be treated as an extraordinate? मैं unsecured loan ले रहा हूं आपसे with interest rate of 50%. I'm taking unsecured loan at a very exorbitant cost of borrowing. That is an extraordinary credit transaction. जो अगर मैंने बाहर से लिया होता, नॉर्मल टर्म्स में लिया होता, सो सीडी का इतना पैसा डाइवर्ट नहीं हुआ होता. So at terms which are extraordinary, inexorbitant in comparison to what the prevailing lending terms are, that shall be treated as an extraordinary credit transaction. Yes, if there are any questions to be taken care of, to be answered, I will be more than happy to address upon your concern. Yes, that will be sent to the institute, and institute will circulate it to all the participants.
Thank you, Vinitji. I think you have covered most of the, and that's a very good presentation, and you have covered all the things. Thank you so much for covering that.
Thank you, sir.
Thank you very much, sir, for giving your time and taking session on the topic PUFE transaction. Thank you very much, sir.
Thank
We
you
have-
to the Institute of Company Secretaries of India. Thank you very much.
Thank you, sir.
Thanks a lot.
So now we can leave.
Yes, now session is over.